population policy in numbers and the flow-ons, regional migration under Kennett. Way under the radar of the general public, the Kennett government began a practice of using the rural category of region in need of migration to reclassify Melbourne itself. Melbourne was thus reclassified a regional migration area by the Kennett government in 1998, which meant it became a destination for people who traditionally migrated to country regions under softer entry rules. Regional migration categories permitted easier entry for immigrants. Rural employers could sponsor workers for positions they claimed they were unable to fill, with fewer tests than urban employers and immigrants coming in under classical federal schemes. They could also sponsor a wider range of family reunions, such as nephews, to work in family businesses. The trend that Kennett started was imitated by the other states. Over time, all the other states also declared their CBDs in need of immigration under regional migration rules. This was also the time of the rise of the internet. Before this time, immigration had been a long drawn-out process that was hard for individuals to initiate or get approval for. Now, Australian states started up state immigration websites advertising state and private sponsorship of immigrant workers and their families. And currently these include, in Victoria, of course, liveinvictoria.gov.com, and in WA they've got one, Migration WA Gov AU, and in South Australia and in Queensland and in the ACT and in the Northern Territory and even in Tasmania, migration.tas.gov.au. Kennett was congratulated by people in favour of high migration for having increased migration to the regions and reversed the long-term trend of migration out of Victoria, much of it to Queensland. This perception was criticised because the so-called regional migrants mostly ended up in urban Melbourne. Nevertheless, I would make the following case that these migration policies and several of Jeff Kennett's other policies were a major factor in creating conditions which would set Australia on a terrible path to rapid and uncontrolled mass migration. And this is all complementary to what Angela's presenting. I just thought I'd make this side clear. Before the Kennett government, most Victorian changes to industrial law made it easier to import cheap labour. Before the Kennett government, most Victorian wage earners worked under state awards which prescribed minimum conditions and wages, including holidays, benefits and penalties for an extensive range of employment roles. Any employee could look these up or have them explained easily by the Victorian Industrial Relations Commission through a hotline called Wage Line, where I happen to work. But in 1993, the Kennett government abolished the Victorian Industrial Relations Act, replacing it with the weaker and harder to enforce and poorly staffed Employee Relations Act. Other Australian states were to imitate this initiative. Unions scrambled to cover employees by registering new awards under federal law, under Section 5135 of the Australian Constitution. These awards, however, had to be negotiated between individual organisations and their employees. Their enforcement was very limited under the federal constitution. They were mostly inaccessible and incomprehensible for individual employees. This right-wing revolution in Victorian industrial law under Kennett in 1993 set the scene for work choices under the John Howard government. The Howard government, entering this weakened industrial law and industrial relations situation, went on to widen the use of the Corporations Clause in the Australian Constitution, which exempted corporations from many employer obligations. Up until now, Australian employers had not had much to gain by importing immigrant workers because they had been required to employ them under the same industrial awards as native-born workers. That meant that there was not the same opportunity to import cheap labour as there was notoriously in the United States. Today we are in a situation where the Australian labour market has been greatly deregulated and it is now possible to employ overseas immigrants according to individually tailored employment contracts where they have little or no bargaining power or recourse for legal protection. Coupled with the deregulation of immigration, this has created local pull factors which the Australian growth lobby has been keen both to lobby for and to exploit. Two further processes have helped to expand the trends that Jeff Kennett's actions set in motion. These further processes were deregulation of the Australian housing market to permit overseas purchase and investment, and the rise of the internet, which was exploited by the state governments, private migration agents in conjunction with employers, universities seeking students, and property financiers, conveyancers, developers and real estate agencies to globalise Australian employment, public institutions, universities and property. Steve Bracks and John Brumby would continue Kennett's big population campaign despite the different brand presentations of their politics. Was Kennett aware of his contribution to setting in motion Australia's unfortunate population tsunami? He was a great population growth spruiker and had formerly served as Minister for Housing, Immigration and Ethnic Affairs in 1981 under the Hamer government. He had made many public declarations on his perception that very high immigration is desirable.